In the world of copyright and online content creation, we often talk about the fair use of another creator's material. Fair use is the legal answer to the question of how much protected material can I use to make my creative point before my use becomes copyright infringement. Well, now, nearly 30 years after the passing of the Digital Millennium Copyright Act, the United States District Court for the Northern District of California is taking up a different kind of fair use question. Judge Virginia DeMarchi has denied a motion to dismiss a DMCA anti-circumvention claim, allowing the claim to proceed. When someone wants to make a fair use of another's work, they have an additional major hurdle to overcome: obtaining a copy of the original work. The claim in today's case is that plaintiff's YouTube video was illegally downloaded in order for a fair use to be made. The most famous case on this channel is, of course, Matt Haas versus H3H3, aka Hosseinzadeh versus Klein. My best pronunciation to date. Sorry, Matt. In that case, H3H3 Productions mocked and criticized Matt Haas using clips of Haas's own video. The judge there decided that the Kleins had made a fair use of Haas's video, and therefore the Kleins were not liable for copyright infringement. Quote, according to the First Amended complaint in this case, Mr. Cordova owns and operates and creates content for a YouTube channel called Denver Metro Audits. Mr. Hunault and Mr. O'Heary own and operate a YouTube channel called Frauditor Troll Channel. Mr. Cordova is the owner of copyrights in 3 videos in this action. The First Amended complaint alleges that between February of 2022 and October of 2023, defendants published on YouTube several videos containing content originally published by Mr. Cordova, including 3 videos incorporating significant portions of Mr. Cordova's videos without authorization. In addition, Mr. Cordova alleges that defendants used various techniques to circumvent YouTube's technological measures, which are designed to prevent unauthorized copying or downloading of videos, to obtain videos of Mr. Cordova's videos from his YouTube channel. In June of 2023 and October of 2023, Mr. Cordova submitted 12 DMCA takedown notices to YouTube requesting removal of defendants' videos. YouTube removed 11 of the videos. Defendants submitted DMCA counter notices on 11 of the videos seeking reinstatement. Now Mr. Cordova asserts 4 claims against all 3 defendants. 1, copyright infringement of 2 copyrighted videos in violation of 17 U.S.C. Section 501. 2, misrepresentation on their DMCA counter notices in violation of Section 512F. 3, a declaration that the videos do not qualify as fair use. And 4, the one we're concerned about, unlawful circumvention of technological measures in violation of 17 U.S.C. Section 1201A. Mr. Cordova seeks damages, injunctive relief, declaratory relief, and attorney's fees and costs. For today's video, I'm focused on the 4th claim, the unlawful circumvention of technological protection measures, aka DRM, or digital rights management, to obtain the source video in order to make a fair use. Why now? Why wasn't this addressed in the last 30 years? Well, because that's how the law and courts work. A plaintiff needs to bring a case, needs to make the anti-circumvention argument. A defendant needs to litigate that issue and not settle, and a court needs to evaluate the issues and make a ruling. Apparently, we don't have extensive case law on this issue, and yes, I'm getting back to the H3H3 case. First, back to the court. Mr. Cordova asserts a claim of unlawful circumvention of technological measures. Section 1201A1 prohibits the circumvention of any technological measure that effectively controls access to a protected work. To state a claim for violations of 1201A, a plaintiff must plausibly allege that the work at issue was protected by copyright, the copyrighted work was protected by a technological measure, and the technological measure was circumvented in order to obtain access to the copyrighted work. The DMCA defines a technological measure that effectively controls access to a work as a measure that, in the ordinary course of its operation, requires the application of information or a process or a treatment with the authority of the copyright owner to gain access to the work. According to the First Amendment complaint, YouTube automatically applies technological measures to published videos that control access to and prevent unauthorized copying or downloading of Mr. Cordova's videos. The complaint also alleges that YouTube's technological measures include rolling cipher technology, which is software designed to prevent unauthorized downloading of videos. This technology encrypts and dynamically alters the video stream's URL signatures to prevent unauthorized downloads. Citing to the MDY Industries case, defendants argue that Mr. Cordova's claim fails and YouTube's technological measures do not effectively control access because Mr. Cordova's videos are publicly available on YouTube. Defendants misread MDY Industries. As the Ninth Circuit explains, the statutory definition of the phrase effectively controls access to a work does not require that an access control measure be strong or circumvention proof. Rather, it requires an access control measure to provide some degree of control over access to a copyrighted work. As one district court has observed, if the word effectively were read to mean that the statute protects only successful or efficacious technological means of controlling access, it would gut the DMCA, because it would limit the application of the statute to access control measures that thwart circumvention but withhold protection from those measures that would be circumvented. Mr. Cordova has adequately pled that YouTube applies technological measures, including rolling cipher technology designed to prevent unauthorized downloading, to his videos on its platform that effectively control access to his videos. Whether the videos may be viewed by the public is immaterial. The complaint refers to the technological measures intended to prevent unauthorized downloading. As other courts have concluded, identifying measures that restrict access to downloadable files are sufficient for the purposes of a 1201A1 claim. The court cites to Ute versus the RIAA, finding allegations that YouTube's technological measures control access to downloadable files was sufficient at the pleading stage. In Edlund v. Basin Electric, the court denied dismissal of a circumvention claim where the plaintiff plausibly alleged that YouTube has many technological protection measures to prevent unauthorized recording and distribution and copying of video content. And UMG versus Kurbanov, finding plaintiff sufficiently alleged a 1201B claim where plaintiff alleged YouTube's technological protection measures included a rolling cipher. The DMCA provides that to circumvent a technological measure means to descramble a scrambled work or to decrypt an encrypted work or to otherwise avoid, bypass, remove, deactivate, or impair a technological measure without the authority of the copyright owner. According to the First Amendment complaint, defendants did circumvent YouTube's technological measures by using software applications or ripping utilities or browser extensions specifically designed to bypass YouTube's technological measures. Mr. Cordova alleges that defendants' tools retrieve and decrypt the obfuscated streaming URLs, enabling defendants to make local copies of plaintiff's videos. Defendants argue that the First Amendment complaint relies on conclusory allegations and describes nothing more than defendants downloading or screen recording a publicly available video. Defendants also fault Mr. Cordova for failing to allege what tools were used and when such tools were used. Defendants mischaracterize the allegations in the First Amendment complaint, according to the court. Moreover, defendants cite no support for their apparent contention that a plaintiff must identify in his complaint the specific tools used to circumvent the technological measures or a date on which those tools were used in order to survive a motion to dismiss. As noted above, the court does not consider and weigh defendants' opposing evidence when addressing a motion to dismiss. Drawing all reasonable inferences in Mr. Cordova's favor, again, the motion to dismiss standard, the court concludes that the First Amendment complaint plausibly alleges that defendants circumvented YouTube's technological measures using the described techniques in order to download his videos, and therefore adequately pleads the third element of the anti-circumvention claim. Accordingly, defendants' motion to dismiss the DMCA anti-circumvention claim is denied. And with that simple ruling, the court has left the door open that the DMCA can be violated even when making a fair use of the source material. The problem is that fair use is the embodiment of free speech, of the Constitution's First Amendment in copyright law. Fair use is a right, not a privilege or an exception to the law. You have the right to make certain uses of copyright protected material if those uses are fair uses, fair with a capital F because there's a lot of legal definition behind that term. But this claim, the anti-circumvention claim, doesn't automatically carry an exception or precedent for fair use. This is important, so please listen up. Even if you properly make a fair use of another content creator's video, you can still be found liable for a copyright violation if you obtained the content by circumventing DRM. And when I say circumventing, I mean the legal definition, which means that even the mere act of screen recording could be seen by a judge or jury as bypassing DRM. Is this absurd? Is this wrong? Yeah, probably. But this is what happens when laws aren't precise enough, when the future thinking isn't clear enough, when intentions go awry. So this claim will need to be adjudicated. The losing party may appeal. The appellate court will rule, maybe rule again en banc, and then maybe a party will petition the US Supreme Court, and maybe we'll get a new ruling in several years. But in the meantime, this claim serves as a reminder that the battlefield of fair use still conceals many landmines that can interrupt your creative endeavors in the most unexpected ways. Oh, and back to the case. The defendant did bring up the H3H3 case with Matt Haas. That case stood for the proposition that reaction videos that follow fair use law are, by law, also fair uses. Well, the court disposes of any defense using that case here. Quote, defendants misrepresent Hosseinzadeh as a decision on a motion to dismiss at the pleading stage. It is not. Nor was the district court's decision affirmed on appeal as defendants contend. In their reply, defendants continued to refer to a Second Circuit decision cited and described as Hosseinzadeh versus Klein 900 F. 3rd 39 50-51, finding fair use as a matter of law. The court can locate no such decision. Defendants say that the mischaracterization of the case and its appellate history in their opening motion was a simple mistake, but they do not explain why they repeat the same mistake in their reply. I tried to find that citation as well. It doesn't exist for me either. But I do agree that the H3H3 case probably doesn't apply here, mostly because I don't believe an anti-circumvention argument was ever alleged. Matt Haas alleged copyright infringement under Section 106, not anti-circumvention under the DMCA. If case law is really headed in this direction, creators need to look out. Using another creator's content will need to be cleared not just for fair use, but now also for DRM violations, even simple ones. A screen recording may still be a violation. I'll keep an eye on this case and update you when I see news. I'm sure the rest of the legal tech industry will also blow up if the court rules that screen recordings are copyright violations even for fair uses. Let me know what you think in the comments below. I'm Leonard French, your favorite copyright attorney. I love you all. Have a good one.